the United States Supreme Court just issued their decision on the case of whether or not states can remove former President Donald Trump from their presidential ballots. Now, anytime the Supreme Court makes a decision like this, social media is full of people praising the decision or angry at the decision, all based on whether or not they like Donald Trump. So it's so important for us to understand what the court actually says and doesn't say, and why they reached the decision that they reached. So what is this case all about? This case centers around the 14th Amendment to the Constitution, and specifically Section 3, which essentially says that anyone under the oath of office, whether military or civilian, that then engages in rebellion or insurrection against the United States government can be barred from ever holding public office again. This was passed after the Civil War, and it was used to keep certain Confederate leaders out of public office after the Union came back together. And in this year's presidential election, 3 states have attempted to enforce the 14th Amendment to keep former President Donald Trump off their states' ballots. Their argument is that the former president is responsible for the actions of January 6th, and those actions amount to rebellion or insurrection against the United States government. So this case comes before the United States Supreme Court. Now, the court has a number of different ways it can go about addressing this. It could address whether or not the events on January 6th amount to being an insurrection. It could address whether or not President Trump is responsible for the events on January 6th. It could address whether or not states have the authority to enforce the 14th Amendment of the Constitution and remove him from the ballot. It could address which avenue states or the government must take if they want to enforce the 14th Amendment to the Constitution and remove someone from the ballot. So which avenue does the Supreme Court take? The Supreme Court decides to answer the question of whether or not states have the authority to enforce the 14th Amendment of the Constitution and remove candidates for office from their respective ballots. And what was their decision? It was a 9-0 decision. And in the 9-0 decision, the Supreme Court says no. That for federal races, so this may not apply to a state race like governor, or a local race like a township supervisor or mayoral race, but in races for federal office, states do not have the authority to enforce the 14th Amendment, Section 3 of the 14th Amendment, and remove federal candidates from their ballot. The court says that this would lead to chaos, where different states have different candidates running for office. And you can imagine what that would look like in the presidential election, where different states have different candidates. There is a scenario where no candidate ever reaches the electoral votes needed because they simply don't appear on enough states' ballots. The court thus rules that this can't be left to the states, that when it comes to federal races, like the race for president, this is a decision that cannot be made by the respective states. There are, however, some nuances in the court's opinion. 5 justices in the majority sign on, and they argue that the group that has to make this decision is the federal legislative branch. The Congress of the United States makes the decision about whether or not federal candidates can be barred from office based upon the 14th Amendment. However, 4 other justices, Justice Amy Coney Barrett writing her own concurring opinion, and Justices Kagan, Sotomayor, and Jackson joining together for a concurring opinion, argue that the court should not have gone so far to say that this is only the decision of the federal legislature. That it was enough for them to say the states don't have the authority to handle this, and not go on to delegate the responsibility to a specific branch or level of the government. That it was sufficient to simply state that the states do not have this authority. So there are some differences in nuance in who the court believes should have the responsibility, but across the board, 9-0, the court believes that for federal races like President of the United States, that individual states do not have the authority to enforce the 14th Amendment and remove candidates from the ballot. And so for those reasons, you will see President Donald Trump's name on the ballot in this fall's presidential election.